GDPR stands for General Data Protection Regulation. It was passed by the European Union in 2016, came into effect in 2018, although actually it was a sort of update and consolidation of data protection law that had been in place for quite some time under a directive from, if I remember correctly, 1998. So what the regulation did was it updated certain aspects of the old regime to reflect up-to-date practices in computing, basically, and also consolidated and codified some of the case law that had built up around the old directive across the various member states. So the regulation, as I say, was intended to solve both the sort of mechanistic problems of divergences of interpretation across member states, and also advances in computing with essentially globalization of data flows. The old directive was oriented around ideas about where your computing equipment was located, which clearly in the modern world of cloud computing and social media wasn't really working coherently anymore. But the underlying principle behind privacy and data protection regulation generally is the idea that people have a fundamental right to have control over how their personal data is used, and to have transparency so that they know who has their personal data and what it's being used for, and certain principles around how businesses, organizations, and public bodies are permitted to use people's personal data. Well, it's actually quite hard to know, because the reporting by, for example, the Information Commissioner's Office in the UK, which looks after the way the law is implemented and enforced in Britain after we have incorporated it into our law, after we left the European Union, they report on things like how many complaints have been made and survey data on how people feel about personal data. It's quite difficult to get good, clear, empirical data about whether personal data and confidentiality are better protected now than before, whether security has improved. In a way, we hear more now about data breaches than we did before, which is potentially a good thing, because that's part of the transparency. So we seem to have more visibility now of breaches, but we don't really have clear information on the underlying facts of whether privacy and personal data and security are better protected now than before. The regulation has been incredibly costly. The implementation costs for businesses have run into the billions of dollars. Businesses around the world have had to invest in compliance because it has extraterritorial effect on any data processing of EU or UK citizens, wherever the processing takes place in the world. But most problematically of all, it's actually really considered now to have had rather anti-competitive and anti-innovation effects. First of all, because the very way the regulation works is state control over what companies are allowed to do with data. And that very much is a drag on innovation, because it deters experimental use of data. It deters it essentially is a form of permissioned innovation that makes it rather costly and risky to do interesting things. And then there's the anti-competitive effects, mainly deriving from the fact that large incumbent companies can absorb the legal and compliance costs much better than smaller challengers can. And we saw this illustrated very well in some research coming out of Oxford University a couple of weeks ago, where they found that profitability in technology firms since GDPR came into effect has been negatively affected by around about 8%. So firms have lost 8% of profits. And the problem there in particular is that this was mainly suffered by smaller firms, whereas Google and Facebook are basically as profitable or more profitable than ever, partly because they've been able to leverage the requirements of GDPR to consolidate their use of data and drive competitors in the advertising market, for example, out of the ad tech market completely. So it's rather anti-competitive. I would have liked to have seen a solution based on freedom of contract and common law principles around confidentiality and actually compensating people for real harm that they might suffer as a result of their personal data being, for example, being hacked or leaked. So rather than the very high concept way that the GDPR and the UK iteration of it treats personal data as being a sort of a principle that needs to be respected, irrespective of any real harm that an individual might suffer, which is why we end up seeing companies being hit with tens of millions of pounds of fines, even though no real damage or harm was suffered by any individual, which that's another anti-competitive, anti-innovation risk that drives over-compliance. Now, the government has consulted about the UK GDPR and some reforms, which, the proposals were heading in the right direction. There was some good mitigations and potential liberalisation of some of the controls on use of personal data. But what I would have liked to have seen was a full first principles review of what do we mean by personal data? The definition of personal data is so broad that it really, in some instances, can cover almost all data that a company uses or processes at all. And the very principle that use of personal data needs to be justified on a number of limited grounds that are available in this sort of permissioned environment. I would have liked to have seen a first principles review of that kind of thing, as I say, taking us towards a contractual based common law solution. Unfortunately, that's not quite where the UK government is taking us so far, but there are some positive signs there in the proposals.